Okay, Ms. Giddens and Mr. Feinberg, y'all ready?
Yes, sir.
Okay,
Yes, Your
so
Honor.
Ms. Giddens, are you going to reserve 5 minutes?
4 minutes is fine, Your Honor.
4 minutes. Okay, that'd be fine.
Yeah, be a
We're
little
ready
different
whenever you are.
All right, Your Honors, I'm Catherine Giddings, and I'm here today on behalf of United Healthcare. Your Honors, in this case, Gulf to Bay filed a complaint looking to get its fair value. It uses the term fair in its complaint over 20 times. And at the hearing, in this case, on the discovery we were seeking, it told the trial court 3 times that the rates that it was seeking were reasonable. And that is at the record at 866, 869, and 907. It has directly placed the reasonableness of its rates at issue, and we have denied that those rates are fair. Now, in this court's decision in Gia Colon versus Helen Ellis Hospital, which this court reaffirmed in Gulf Coast Surgery versus Fisher, this court determined that information that we are seeking here, which is on the GTB's internal cost structure, and it's what it accepts as negotiated payments from Medicare Advantage and managed Medicaid organizations, is not only relevant, it is critical. In this case, without this information, United is being prejudiced and it is being deprived of its due process rights to defend this case because 1, there's no substitute for this information. 2, it's clearly relevant and material to refute GTB's claims that the rates are fair. The information may very well change the outcome of this case, and there is no way to determine at the end of the case what impact this information would have had on the outcome. I would suggest to you, when you were talking in the earlier case about the steep hill that you have to climb in a certiorari proceeding, that this case, as Gia Colon has stated, and as this court stated in HEPCO, this is the classic example where certiorari is needed.
Excuse me, let me ask you about Gia Colon. Isn't that a case where the hospital was trying to recover charges from a patient?
Yes, Your Honor.
And the issue, the patient was saying, well, these charges weren't fair. And I believe, is this the case where they cite to an 11th Circuit decision that lists like 4, 5, 6 factors, one of which is the cost structure, in determining whether in collecting from a patient, the charge was reasonable?
Your Honors, it was a patient, but as this court said in Gulf Coast Surgery, which was actually authored by Judge Morris, it applies not just to patients, it applies to third parties seeking reasonableness. And make no mistake about this, what United is seeking here impacts not just United, it impacts its members, and this cost will be reflected to individual patients.
Well, you know, this is an interesting case, and I read much, if not all, of the record, including hearing transcripts, and there's really a lot more that underlies this case than what is just apparent here. And I understand that this is a bigger issue and that United has an issue nationally with this type of, where you have a private equity business taking over a physician practice, et cetera, et cetera. So I understand all that. And part of my reaction to this is, it seems like to me your problem really is a bigger problem than whether these particular bills from this particular group are reasonable and payable, and how they're payable under our statute. And maybe you're barking up the wrong tree, but that's really an aside. But one of the things I got out of this when reading the hearing transcripts and some of the background information that was provided, talking about the Texas litigation, is really, I think there was testimony in the Texas case that was referenced at that hearing that their costs are untethered to their charges. So really knowing the costs it may not get you anywhere, because what they charge is not based on what things cost them.
Your Honor, I would strongly disagree, because if you look at the Colomar decision, which was a district court decision, not the 11th Circuit's decision, which this court relied on in Gia Colon, it says that you need the internal cost structure information, because even if the charges match what other healthcare providers charge, it may still be a gross overcharge relative to the provider's cost, and thus an unreasonable, unfair amount. And Team Health's president put at issue in this case the internal cost structure, because he said in a statement, which is attached at our record at the supplemental appendix 68, in a statement that is on their website, that they use the charges for most payors to subsidize the low income services that they provide. And so we have a right to know, what are they charging? Now, remember, this is not a free market as you would normally think about it. This is not a case where United is going out and deciding to get its hair cut.
Right, they're the only ones. They're an exclusive provider in these hospitals.
Exactly. And I think you have a good grasp of this, Judge Kelly. And I think that if you look at this, you can see that this is more like electric service that you receive at your home. I mean, the charges have to be reasonable because you're captive. You're not, the utilities cost is directly relevant to setting a reasonable rate. And just like the patient in Gia Colon was a victim of the market, here United's insurers are victims of this skewed market. It's a disrupted market. And so we have the right to go in and look behind that. And we also have the right.
Ms. Giddings?
Yes.
Ultimately, the question under the statute, and help me understand if I'm incorrect in this, is whether the charges that United is paying, or whether the charges that the anesthesiology practice is charging are usual and customary, because you're not going to pay the bill charge, we know that, and you haven't agreed to an amount. So that leaves us with usual and customary. And that's where I'm having trouble with the cost.
Your Honors,
analysis.
There's a reason why they bought the common law claims. They brought unjust enrichment, implied in contract, and quantum merit, because
that's the door that gets you into costs. Because
that's exactly well.
It has that different language.
I would submit that costs are relative to usual and customary as well. But keep in mind that United administers. Well, United administers, this is important to understand. United administers claims for self-insured plans, and they fall outside the statute. So it's my understanding that's one of the reasons why Gulf to Bay had to bring these common law claims. They do not even fall under the statute. And
well, I think I actually made a note of this when I went through their complaint, is this, while the statute speaks to usual and customary charges, these other counts, the common law counts, speak to fair value. And I think your argument with respect to the cost data goes to the fair value and not necessarily to proving or disproving the usual and customary charge. Is that right?
Well, Your Honors, we do believe that it goes to the fair value, but I also would submit to you that usual and customary has to be fair. As we cited to the court in the Castellanos decision, the Florida Supreme Court has said that the legislature can't set fees or tell you what fees are with an irrebuttable presumption that you can't come in and challenge that they're reasonable. And you know, they rely a lot on the Baker County case. And I was actually counsel in the Baker County case. I represented Aetna. And that is a very, very different case, because what happened in that case was the hospital said that we are the only provider in the community, so you have to pay our bill charges. And the trial court set forth the list of all the cases that had to be all the things that were considered in determining usual and customary and whether they're billed charges, it said that you have to look outside just that one hospital. You have to look at other providers. And so,
Right, but the usual and customary, I just keep coming back to the cost to me. I mean, whatever it costs, if it costs 5 cents to do it and they charge $5,000 and that's the usual and customary charge and everybody does that, I don't see the relevance of the cost to use, but I am more receptive to the argument that the cost might be pertinent to determining fair value.
well,
So
Your
help me
Honors,
with that.
I think it's really important for you to understand that the Gulf to Bay is not a facility provider. It might have brick and mortar for administrative, but it comes to the hospital to provide its services.
No, I understand that.
And so in evaluating usual and customary, you have to be able to look and see what its costs are, because its costs may be much lower than other people within the market. Yes, Judge LaBrette.
Let's get back to certiorari, because what we're dealing with here is the denial of a discovery request. And ultimately, at the end of the trial or whatever proceeding, it becomes dispositive between United and these anesthesiologists. There'll be a judgment entered, and either United will walk away from this or they'll have a judgment for X amount of dollars. And that judgment will be on one of these theories or more than one of them, at which point United will have the opportunity to raise whatever, let me finish, whatever errors they claim were relevant to how the damages information was compiled. And for that reason, and I think I probably sound like a broken record today after the earlier arguments, I am struggling with how we get to irreparable harm in this case. I'm fascinated with the discussion of HMOs and billing structures and anesthesiology practices. I've worked in those areas. It's interesting to me, but ultimately, we're in this little box of, does the denial of this discovery result in irreparable harm that can't be cured on plenary appeal? And I'm not sure I'm there yet.
Yes, sir, Your Honor. And I gave a lot of thought to that because I've been an appellate lawyer for a long time, and I know that it is difficult to climb that road. But in this case, it used to be the district courts were split on your issue. And some courts, like the 4th DCA, wouldn't even consider an order denying the right to discovery. But in the Plant decision, the 4th joined its sister courts, and now all of the district courts allow certiorari review under circumstances that are exactly like the case here. As I stated earlier, there's no substitute for this information, and it's clearly relevant to refute their fairness. It may very well change the outcome of the case. And we're being deprived of our due process rights because you don't know at the end of the case whether the error was harmful or harmless. So you know now, under special, they have got to prove that this error was harmless at the end of the case. So you know right now, if we don't get this discovery and we establish that we should have gotten it, which we think we have already done, then the trial is going to be reversed. And so that is why you have to look at this case under certiorari now, because we meet that test. We don't know. I mean, it may be that we'll get this internal cost structure information and it won't show what we think it will show. But what we believe it's going to show is that Gulf to Bay and its parents are grossly overcharging, which is going to impact what each of us pay for our premiums, or if there's a large deductible. This is not.
Let me stop you right there. Let me stop you right there. You said that they're grossly overcharging. Okay, how are you going to show that? Because I think your argument is there is really no, there is no market. They are it. So there's no one to compare them to. So where are you going to get to their grossly overcharged?
No, Your Honors, I'm sorry. That was the Baker County case where that hospital said it was the only game in town. What I am saying here is you look at what other provide, you look not only at what Gulf to Bay accepts and among all these different payors, you also look at what other anesthesiologists charged. And that's where Colomar comes in, because it says, even if the charges match what other healthcare providers charge, Gulf to Bay may still be, its charges may still be a gross overcharge relative to the provider's cost, and thus an unreasonable, unfair charge.
How is that measured? Like, who gets to decide that?
Well, what you do is once you determine
how much profit they're allowed to make.
Once you determine that, remember again, this is not in the market where you would not normally look at.
No, I understand what they've done, and I understand the bigger picture here, but I'm also really struggling to see how the cost structure, having that or not having that, makes or breaks your case.
Well, Your Honor, I would tell you that I would suggest that this court has already decided that issue in Gia Colon. And
well, isn't it really, and I don't mean to interrupt, but I just want to get a word in edgewise here, because I'm very focused on the evisceration of your defense, which is really what we have to look at here.
Yes, sir, Your Honor.
And your theory is, as you very carefully articulated what your theory is, and there's a basis for your theory as I see it. We may not all agree on whether it's going to carry the day or not, but there's a legal basis for your theory. And so without this information, your defense on that basis is eviscerated, is it not?
Yes, sir, Your Honor, you're absolutely right. You know, like I said, I gave a lot of thought to the certiorari process here and what does evisceration mean? And, you know, the standard is that the trial court denied material discovery. We know it's material to our defense, which was very likely to produce evidence that would be admissible at trial or go to an expert's opinion. And if the evidence establishes what the party believes it will, would likely change the fact finder's decision as to either liability or damages. And in the absence of this discovery, the issue is unreviewable on direct appeal, thus denying the requesting party due process to prosecute or defend the case. As a result, the error is properly corrected on certiorari review as a departure from the essential requirements of law. And that is the test that comes from all of these different decisions on what effectively eviscerate means. We don't know what impact this is going to have until we get this, but we do know it's clearly relevant.
Ms. Giddings, you are over your time.
I'm sorry, Your Honor.
That's okay. It's my fault.
I should have been looking for
No, but that was really helpful.
Thank you.
Okay. Mr. Feinberg, it's your turn.
Thank you, Your Honors. May it please the court. Justin Feinberg from the law firm of Lash and Goldberg, here on behalf of the respondent, Gulf to Bay Anesthesiology, which I will refer to today as either the respondent or Gulf to Bay. Respectfully, the petition for certiorari should be denied. The petitioners cannot meet their high burden to demonstrate any one, let alone all of the essential elements. And I've been thinking about that burden in the context of the Olympics. And Judge Morris, you referenced it as a steep hill to climb. I wrote down that
It is a steep hill to climb, but if preventing, and I'm sorry to interrupt you, I want to hear about the Olympics, but let me just get my thought in.
Sure.
I mean, if you have literally eviscerated their defense, I think you're on top of that hill.
This case does not even come close to eviscerating a defense.
Okay.
And let me explain to you why. There are a number of reasons, and we've talked a lot about the cost discovery. So let's talk about the cost discovery. But first, let me talk to you about what has been ordered to be produced in the case. And I think, Judge Kelly, you were asking about the narrow focus of what we're talking about on this appeal. Now, at the hearing before Judge Sabella, when we were arguing about the scope of what was going to be exchanged, Judge Sabella ordered all payer information to be exchanged. That is in the record in the respondent's appendix 239 at his paragraph number 3. I'm sorry, it's number 5. No, it's number 6. Discovery shall not include payments from Medicare and Medicaid, except as set forth in paragraph 7 below. Discovery will include payments from other payers. So the discovery that has been exchanged in this case has been consistent with Baker County, and we have exchanged all of that information on our side and from United's side. Okay. And now when Ms. Giddings refers to what I said at the hearing about reasonableness, what I said about reasonableness, when you read the transcript of the hearing, what I said at page 866 is I said, what is the rate of the implied in fact contract? The jury will decide that. It's going to be the usual and customary rate or a fair and reasonable rate in the market. And the legislature has set forth a framework for that. It's the lesser of methodology of our charges or the usual and customary provider charges for similar services in the community. And that's the jury question. And what
Again, I'm with you as far as what the statute says, but you know, there's also these common law counts where you specifically use different terminology and you refer to fair value.
We do absolutely use the word fair value in the amended complaint,
And
but you need
said
to
you're
look
not paying a fair value, and then they've got to respond to that. And they're saying, well, yeah, we are, because here's what it costs. Here's what you're charging. That's not fair. Why is that not a valid argument?
because you need to look at that allegation in the context of the other allegations of the amended complaint, specifically paragraph 22, which is incorporated into all of the common law claims as well. And in paragraph 22 of the amended complaint, we made it clear that they were underpaying our claims because they didn't pay the lesser of charges or the usual and customary provider charges for similar services in the community. So the issue in this case, which Judge Kelly, you hit on the head, is different from GIAC alone. The issue in this case is you actually have a statute that sets forth the methodology for what the payment rates would be. Now, what's important and what Judge Sabella found was that costs is not a component of the statute.
Okay, I'm going to try to steer you back to talking about the quantum merit, the breach of implied in fact contract, because I read the statute and I know what the statute says, and I have, as I've already expressed, some difficulty seeing the cost data being pertinent to a defense against the statutory counts. The common law counts are different. The way you have alleged them and just knowing what those is entailed in those causes of action, but you have specifically used, quote, fair value. You've used, quote, fair value in count 3. You've used it in count 4. I think it's in count 5. So let's talk about those and the cost data.
Absolutely. So as I mentioned, you need to look at that allegation of fair value in the context of how it's calculated, reference to paragraph 22. So we specifically identify that
not to interrupt you, is your theory that fair value is equivalent to usual and customary for purposes of your common law claims? Is that your
Is that what you're saying?
Yes.
Okay, you're saying it's all the same.
Yes.
Why'd you use different words?
we just use different words, but we incorporated the same methodology, the same idea into the common law claims. So in our view, as alleged in the complaint, and frankly, how discovery proceeded, that is how we proceeded with discovery.
So all you're going to ask a jury for, no matter what theory of liability, what count they're being instructed on, is usual and customary in accordance with the statutory factors.
Absolutely. That is exactly what we're going to do. And what's very interesting, Judge Libbert, to answer your question is, when the experts have rendered their opinions in this case, there isn't a difference. There's no difference between any statutory claim or common law claim. The difference of fair market value or fair value or the statutory methodology, it's all the same, because that is what we're going to present. We're not going to present a different methodology for that to the jury. And that's critical, right? Because all of us have understood, and even if you look at the defenses that United raised in the case, and this was part of what was important to Judge Sabella, is that there wasn't a claim of unreasonable pricing. because Judge Kelly, we didn't ask for specifically billed charges, which is different from Giacalone, where there was a claim where the whole issue was the hospital said there was a contract with the patient based on the admitting forms to pay the value, which was billed charges. So the issue, the critical issue, core issue in that case was the billed charge, the price term of that contract reasonable? That is very different from what we are alleging here, which is that the reasonableness or the fair value is measured by the statutory framework, which the legislature has already said, this is how you do it. It's lesser of.
Mr. Feinberg,
Yes, ma'am.
talk to us, just give us a little more color on how your experts both line up on the damages methodology and base it on usual and customary. I'm assuming the experts don't agree to what your damages are, but if what you're saying is the experts are essentially using the same methodology to arrive at different numbers because they're both ultimately looking at UNC, then we need to hear a little bit more about that.
Sure. So, and definitely the experts are looking at usual and customary, and they come at it from different ways. And I think what's really important also I want to make clear, okay, is that the methodology that either side's expert has utilized comes up with a dollar value, okay? So in their briefs, United made a big point that we are relying on our charges because we're calculating our damages as a percentage of our charges. And that is just an expression of a measurement, just like you could use yards or feet or inches to measure. Ultimately, because this is anesthesiology and most of the services are billed in timed units, both experts have come up with an amount that they believe is the appropriate measure of a timed unit. And that comprises like 90% of what we're talking about in the case. Our experts look at it differently because they say, look, you need to look at these, you need to weight the evidence differently. But they look at what was paid in the market and what was accepted in the market, just like United does the same thing.
Is that those are the usual and customary. That's the same analysis in both experts' opinions.
Yes.
They go to determining what is UNC.
Yes. Yes. Then we get into this other issue about whether they can add in this government and the government claims. But to answer your question directly, Judge LaBritte, that is the way that the experts are looking at it. They're looking at what was paid in the market, what was accepted by others in the market. And some of our experts may weigh it differently than their experts. We get different numbers. It's a big number on their side. It's a bigger number on our side. But that is how we come up with it. Okay. Yeah. And so I just want, let me see how much time I have left. But I'd like to just really talk about the effectively eviscerate standard, because what you're talking about here is really the exercise of judicial discretion, really at its core, because the judge looked at the facts of this case, looked at what was alleged in this case, looked at what the discovery was going to be in this case, and the judge made decisions. I didn't agree with all of the decisions that the judge made. We wanted limited discovery to a smaller community in Florida. The judge says, look at the whole state of Florida. That was his discretion. He exercised that. Just like he exercised and said, I'm going to order all other payment information to be exchanged, but I'm going to limit it. And I'm not going to allow the cost discovery because that's not what is pleaded. That's not put at issue by their defense or our claims, because it's different, Judge Kelly, again, from Giacalone. The standard is not, we're not saying it's absolutely X as the rate. We're saying the jury can determine that based on what is usual and customary. And United didn't raise a defense. And in fact, in affirmative defense number 6, what United did is they adopted the Baker County analysis. And they said that it has to be modified by what's usual and what's customary. And we agree with that. We're not running from that. We're adopting the Baker County analysis. And so we don't believe that costs, and Judge Kelly, we had the same concerns about costs as you did for a slightly different reason. But how you would measure what the costs are relative to the service and making that comparison to other providers in the market and what that would ultimately show, it doesn't go to your usual and customary charges. It's what I explained to Judge Sabella. If you want to get the price of a phone, you don't get to argue about how much it costs. You go shop it around what others are charging in the market and you figure out what is the value. And Judge Sabella hit it on the head, right? It should be fairly simple to figure this out, right? And we think it is, based on the information that's already been exchanged. in the discovery that really goes to what are the theories in this case. And I know my opponent, Ms. Giddings, put together a nice package of what would eviscerate a defense, but you could say that about every discovery ruling, right? You could say that about every discovery ruling, that somehow that may change the outcome of a case, right? But their defense is not eviscerated, not even close. And I want to end on this one last thing. They have filed a petition for writ of certiorari claiming that they are entitled to government claim information, when in the discovery in the case, they asserted an objection, even though we didn't ask for it, an objection that said, we are not producing the government information. And now they come in when their experts had a big number. They do 180 degrees after we argued this to Judge Sabella. And they
now
say,
they
oh,
want
this is effectively eviscerating our defense. I apologize, Judge Kelly.
No, I just interrupted because I know they said, no, this isn't discoverable. And now they're saying we want it.
Right. And with that, I would just say to your honors, again, and Judge Morris, I know we could talk about the Olympics, whether it's a high bar, a hurdle, a steep hill to climb, they're not winning any medals. They're not even placing here. All right. And respectfully, unless the panel has any questions, I would rest on our briefs and ask that the petition be denied.
I was really worried you weren't going to get to that Olympic analogy, which I knew you had at the bottom of your briefcase. Thank you, sir. Ms. Giddings, you have 4 minutes.
Yes, sir, Your Honor. First of all, I would like to say that it was not an abuse of discretion. These are matters of law where the trial court erred, because this court in Giacalone held that these factors are relevant to a determination of reasonableness. As to his objection of stating that we objected, we withdrew that objection, and he knew we withdrew that objection. Your Honors, that's a red herring. We've already produced that information, and we believe it's relevant.
Ms. Giddings,
Yes.
speak to the issue of if your experts have ginned up a report that assigns a number to this that's lower than whatever his experts have said. I'm sure that you have a good answer for this, but tell us why, if your experts have been able to do all that, your defense is eviscerated. And I want you to address specifically his contention that ultimately what they are looking for, the number that they're driving for, is based on the statutory factors for usual and customary.
Your Honors, our expert, as I understand it, was retained to refute their expert value on fair market value only. And that expert stated that his report could not be complete without the Medicare Advantage and Managed Medicaid, which are not government claims, they are negotiated claims. And we did not have this information yet for the experts to be able to consider as to whether the rates are fair and reasonable. And I would suggest to this court that this court has already held that internal cost structures are relevant. And look at Colomar, look at Giacalone, and I think you will find that that ship has sailed. This court has made that determination. They now say, if you look at what they're arguing, their argument is very illogical. They're saying, we admit that our bill charges are unreasonable. We're not asking for that. But their experts are saying that we have to pay them 80 to 90% of those billed charges. So we're entitled to determine whether that is fair. And they want you to just look at the statute. But again, you can't have a statutory scheme that sets rates and tells you what you have to pay. And it's a violation of federal and state due process to not allow a determination of reasonableness under those statutes. And time again, the courts have determined that in situations like this, you get to look at reasonableness. So you don't just look at the fair market value from Baker County, because reasonableness was not an issue in that case. And if you read it as prohibiting it, then that case is not binding and it conflicts with Giacalone. So Your Honors, this has real world impact. These outrageous prices that they are charging, they are now, it's my understanding, they were charging about 600% of Medicare. They're now charging about 950% of Medicare. This is outrageous. It has It has a tremendous real world impact on everyone that pays premiums and has high deductibles. And we would ask that you quash the orders under review and you permit access to this internal cost structure information and information regarding managed Medicaid, managed Medicaid and Medicare Advantage, tongue twister there for me. And with that, we would ask that you grant cert, Your Honors.
Thank you both very much. Your briefs were excellent, and so have your presentations been today on this very difficult and important case. I can't thank you enough. Have a good day.
Thank you.
This concludes our docket for this morning.